Good afternoon. May it please the court, John H. Rees on behalf of the appellee. For the reasons that follow, this court should sustain and affirm the certification order. Let's talk about the standing issue. There are 4 distinct reasons why the standing issue fails right off the bat. Number 1, this court should be made aware, which opposing counsel has not made you aware, that the identical facts, the identical case was already appealed to the 11th Circuit U.S. Court of Appeals. This is the identical set of facts. And in that particular appeal, this is what the 11th Circuit U.S. Court of Appeals stated. IDS argues that the assignments were invalid and that MSPA Claims 1 therefore suffered no legally cognizable injury. Though IDS was the only defendant to raise the issue, its argument equally applies in all of these cases. So what happens is this is the law of the case.
So you're reading from Allstate, right?
I'm reading from the Allstate decision. This is the identical issue they raised.
The opposing counsel states that, and I want you to address this, states that that was dealing with the federal anti-assignment statute, not the assignment issue that we have in this case.
Your Honor, Mr. Cantero was a justice of the Florida Supreme Court. He knows that all issues that could have been raised at an appeal, it should have been raised. They were dealing with the actual document, the underlying document that they claim doesn't serve as a basis for an assignment. Right off the bat, there's no way that this court should superimpose its decision and basically disagree with the 11th Judicial Circuit, stating that this was a valid assignment. And by the way, Allstate raised the issue with the 11th Circuit U.S. Court of Appeals that this was a proper assignment.
Counsel, you're certainly right that issues that could and should have been raised are seen as decided in certain contexts. But one exception to that, as I understand the law, is jurisdiction or jurisdictional issues like standing. And there, as I understand it, courts are not seen to give implicit rulings on jurisdiction because of the difficult implications those have.
There are very, very narrow exceptions, none of which the court announced, because the underlying documents that were utilized for the assignment and were raised by one of the other defendants. So the court did look at it. It's not like they didn't look at it. Now, that's just one of the reasons. Now, the second reason is the Florida Supreme Court has stated that once a court obtains jurisdiction over 2 parties, that court has exclusive jurisdiction. The only court that could have determined whether or not they were standing between these parties was the Leon County judge, who determined that they were standing. At most, what IDS should have done was ask for a stay of the proceedings and gone to the Leon County judge and determined whether or not they were standing. Now, Judge Scales, you indicated in one of the prior appeals, how can they even have standing if they were part of the contract? Now, there's other reasons why. So they didn't have no standing. There could have been waiver on the part of the state at that point in time, but even further than that, the actual agreement states that there has to be an approval to assign the contract, not the claims, not the underlying claims. The claims were assigned, and plus, once you take an assignment, you own that. You can do whatever you want with it. At most, the state would have had to breach a contract because you breached the contract. The transfer of title is not affected by this provision at all. Further to that, just because somebody files a motion and takes a position, there's no judicial adjudication. It's preposterous to state that somebody just simply files a motion and then that all of a sudden disavows and disallows you to make a transfer. It just makes zero sense. And for those reasons, and opposing counsel hasn't provided that information either, there are way more cases throughout the entire United States that have allowed for these cases to proceed. Moreover, on June 1st, 2016, the state, the judge in the underlying case, which did have jurisdiction, approved an agreement and stated that the transfer was valid, that the assignment was valid, and therefore this court should not disturb that. A step further, there was evidence in the record, Judge Lux.
Is the problem, though, that adjudication happened after the lawsuit was already filed? In other words, don't we look at standing at inception and not standing about what happened afterwards?
Yes, but there was never an adjudication that there was no standing. There was never an evidentiary hearing to determine that the facts as demonstrated weren't the facts. There's nothing other than an agreement to transfer between the parties. The parties agreed to the transfer. At most, when a third party, basically the state, jumps into the picture, they take the position, we're canceling everything. Well, guess what? The cancellation of a contract has zero effect on the assignment that already occurred. That had already occurred. What the opposing counsel confuses us with is subsequent assignments of claims. Now, had one of these claims surfaced subsequent to the cancellation, then arguably they may have a much better argument. That doesn't work. Now, let me jump into the certification. Judge Luck, I know you were on the other panel that dealt with the Ocean Harbor case, and I want to focus on some of the questions that you raised, because I thought they were good questions, and I want to make sure...
You would be the only one in the room.
Okay. So, here's what I think is the pivotal point of these cases. These cases stem down to the simple process that follows. Is the person that made a claim to IDS a Medicare beneficiary? Yes or no? Did Medicare make a payment to any of those individuals? Yes or no? It's as simple as that. If they did make a payment, the next facet of it is there a system that can determine on a class-wide basis whether or not any of these payments were made as a result of an automobile accident? And the answer is yes, because the federal government, CMS, has the actual numbers that are what they call external causes of injuries and other codes that determine that these are related. So this is not in a vacuum.
Isn't the issue, though, and I want to fast forward just a little bit, you cited the Western Heritage elements.
Yes.
And if this were a tort claim, I would understand and agree completely that that's the situation we'd be in. But Allstate seems to suggest that, and I think your opposing counsel read that portion of Allstate, which suggests that the contractual defenses remain. Given that there's those contractual defenses, doesn't that make it very individualistic, each claim, of whether demand and notice have been given, whether it's related, whether it's reasonable, whether it's necessary?
What the Allstate decision states is that the plaintiff still has the burden of proving their case and the defendant can raise defenses. It does not state that the defense of reasonable, related, or necessary without exhausting administrative remedies is a viable one.
So that's the issue. They haven't exhausted.
Well, yes, and preemption. There's so many. Look, this is really a boxed-in area of the law, and in my 26 years of practice, I've never seen such a lopsided law. This is basically created for the federal government, and it basically states as follows: if Medicare pays, you got to pay them back. We got to understand some real fundamental issue with this. These are claims that have already been paid. These aren't claims that are being sent to an insurance company for them to make a determination. These are paid claims.
Your opposing counsel gave two responses that I want you to address today, because I tried to, as best as I could, represent what I thought your response would be. Number one, he says that...
You did a good job.
Thank you. I appreciate that. Number one, he says that it only applies to enrollees, that the administrative requirements only apply to enrollees. Number two, he says that there are counter regulations that state that, or counter statutes which state that if at some point at some time period, it's the beneficiary who has to contest, not the insurer or the third-party payee.
Respectfully, he cited the wrong numbers. 41125 says nothing of that. 41125 states that once there's demonstrated responsibility, the insurer is supposed to provide a plethora of information to the Medicare secondary payer. Name, HIC number, MBI number. So that doesn't say any of that. What is at core, the core issue here, is that state laws are preempted. This court's ruling in Real does not focus just on an enrollee. The Medicare Act encompasses any claim or a controversy regarding Medicare payments. We cannot read the Real case to state it's only an enrollee. As a matter of fact, Humana versus Western Heritage deals with an insurance company. It was not Humana versus Real. It's Humana versus Western Heritage. And the United States Circuit Court of Appeals stated that because Western Heritage didn't fulfill their administrative remedies, Ms. Real didn't, it's on them. The core essence here is that the Medicare payment is made because the Medicare beneficiary has the rights to receive those payments. If somebody's contesting, like in this case, IDS, that the payment that was made for and on behalf of this enrollee was inappropriate, it still goes back to they're making a claim that the enrollee's payments were improper. It always goes back to the same thing.
They're not contesting that Medicare's payment was improper, but they're contesting it, well, as I understand it, and maybe they are, but as I understand it, what they're contesting is that they don't owe any money. They're not saying that Medicare, if you're 65 and over and you have some sort of medical injury, you're going to get coverage. The question here is, are they on the hook also?
Your Honor, that's what a reimbursement case is all about.
I understand. What they're saying
every reimbursement case is like that.
What they're saying is there's defenses to me being on the hook that make this and put this in a little different of a posture.
Well, I don't know of one case in the United States of America that states what they're stating. The only case that they mentioned, which is Caldera, is a completely different set of circumstances. That dealt with pre-authorization for treatment. In essence, a condition before you're even covered. PIP doesn't apply that way. Caldera has a very, very limited application because under the context of workers' compensation, that's the way that the system works. So essentially, MSP versus Allstate states, if you have a contractual obligation, you better pay. Now, can they have defenses? Sure they can have defenses, but just like any other party, like an ERISA, everything else, they better make sure that they fulfill their administrative remedies. Now, to finish, because I know I'm running out of time.
You have 1 minute remaining.
Yes. Here's really the crux of this. There was zero evidence in the record, okay? And all of these potential defenses are essentially red herrings. There wasn't one case that this insurance company brought to that hearing where they were able to take the position that the bills that were submitted to them were not reasonable, related, or necessary. As a matter of fact, they processed them all through a computer system. The same computer system that the United States government uses to determine whether these numbers match. There is zero evidence. We can just throw up we have defenses, but you better have evidence in the record to substantiate that you in fact have defenses. On cross-examination, when I asked Ms. Health, she said, it's a computer system. It's a process. I want the panel to understand, this is not, there are millions and millions and millions of health claims processed every day in the United States of America. There isn't somebody sitting there looking to see if the code matches. It's a computer system, and it's pre-programmed. That's the reason why there's superiority, why there's commonality of issues, because the issues to be tried in the case, and again, we can win or lose, but here the issue is going to be tried in the case. Do we have a set of codes that are recognized by experts in the industry, by CMS, and by this insurance company, party admission, that must be paid when there's a car accident? Yes or no? It's as simple as that. So here's what the judge could do. The judge could determine that there are certain codes that are not applicable and are not payable. So I don't want the panel to leave with this concept of, oh, we're going to be paying bills that aren't due and owing. This is an automatic process. And the reason why it's an automatic process, and I want to finish with this, I want to make sure these are paid claims. This money already left the Medicare Trust Fund. This is money that the government should have never paid. To put an onus and burden on the United States government of trying to jump through all the loopholes that these insurance companies want to make you go through is exactly why there's preemption. Exactly why the federal government created these laws that states, and I think Judge Luck, last time you asked me, a contractual obligation. In the ruling in Real, it specifically states that 422-402 concerning federal creation of state laws, the rules established under this section supersede any state laws, not just the sub-provisional.
Counsel, is reimbursement required even if the PIP benefits have been exhausted by the insurance company?
It depends on the timing, Your Honor. Under certain circumstances, yes, that could be picked up by the timing of the payment. In fact, in this case, IDS paid. We acknowledge that they paid. But we paid the same bill that they should have paid, and by the way, it was shown.
So why can't the county court make those individualized determinations? The county court in an individual PIP reimbursement situation? Because then you'd have thousands and millions of cases going through the county court for no reason. There's a common core that is present in all of these cases. They're Medicare beneficiaries, payments have been made, they're supposed to be reimbursed, and there's 3 elements as announced in Western Heritage, in the Western Heritage case. But let me I'd like to make sure, because I want to make sure that I read this.
This has to be your last one.
It is, and I apologize and I thank you at the same time. So under this section, which is the preemption, it supersedes any state law. It doesn't pick one versus the other, any state law. Regulations, contract requirements, or other standards. The last time I was here, Your Honor, you asked about contracts. PIP has to be governed by the statute, which governs the contract. There is no way out for IDS or any other insurer. The system is strict, and by the way, the burden and onus is on them to make sure that when a claim comes in, that they investigate that it's a Medicare beneficiary, and that if somebody paid, they reach out to that particular payor, which is always a Medicare payer, and they come to the plate under 4925 and say, we're first, we're here to pay. For the reasons that I announced, I would ask the court to affirm the certification order. Thank you.
Very much.